Lordship. Lordship, here, my lord, I have challenged the order, page 162. By this order, learned trial court, my lord, allowed the amendment petition. Now, in this case, that issue has already been framed.
Pardon?
Issue has already been framed, my lord, in this case, in this suit, my lord. And also, also, at the stage of suit is at the stage of evidence. So, my lord,
Whether evidence was laid?
Evidence for fixed for evidence on 20th next tomorrow, my lord. It was fixed, but in the meantime, amendment petition has been allowed. So, I have challenged on the ground, my lord. First, I'd like to take, my lord, to page 39. Before filing the suit, they have issued a pleader notice. That is, my lord, page 39. Schedule of the land, my lord will get, this is the advocate notice, page 42.
No, forget about advocate notice. So, what is there in the plaint?
In the plaint, their suit land is 6 biga, 3 kata, 15 lessa. Now they are altered the land to 4 biga, 4 kata, 12 lessa. So it will change.
They have shown a ground.
No, my lord.
That earlier there was a katsa patta. And subsequently, periodic patta was issued.
But my lord, the rule 6, my lord, 17 provides that due diligence must be there. My lord, in the kindly come to amendment petition. That is, my lord,
page number?
Page 149.
149.
149. Due diligence must be there, my lord. Page 149. Only ground that, my lord, paragraph 1, third line, due to missing of a document, some omission and commission made in the plaint, the copy of final patta. So only this, my submission is this is not sufficient ground, my lord. Due to, in the plaint, nothing about the final patta 77. Even in the amendment petition, there is not a single whisper, no statement how they could not brought before the learned trial court earlier. Due diligence is not there. Nothing, my lord. Only they have a due to missing of a document.
Let notice go.
In the meantime, my lord, further proceedings, my lord.
No.
For my lord, fix it. Staying further proceeding, my lord.
After?
Staying further proceeding, my lord. After next step, my lord, fix. Because, my lord, in notice they have stated something, in plain.
No, let us do one thing. Let the trial go on. We'll fix a very short date. You effect service of notice upon the respondent. We'll finally hear the matter.
My lord,
shortly.
My submission notice, let the notice go. In the meantime, as a status quo, maybe, as it will remain same, my lord. Call for the record.
No, let us make one observation that this amendment will subject to the outcome of this.
My lord, notice, call for the
outcome of this civil revision petition.
Notice maker.
Heard, Mr. Khandekar, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India is preferred by the petitioner by 5 petitioners who are the defendant in title suit number 152 of 2022 pending before the Court of Learned Civil Judge Junior Division number 3 Dhuburi. And they have challenged the order dated 5/1/2026 passed by the passed by the Learned Civil Judge Junior Division number 3 White which the learned civil judge junior division number 3 Dhuburi has allowed the amendment petition filed by the respondent hearing. Mr. Khondokar submits that the case is pending at the stage of evidence and without showing due diligence on their part, the petitioners, no, the respondent hearing filed one petition under Order 6, Rule 17 for amendment of their plaint in the title suit number 152 of 2022, and the learned civil judge junior division number 3 Dhubri has allowed the same. And as such, the impugned order dated 5/1/2026 suffers from illegality, and as such, the same requires interference of this court. Mr. Khondokar further submits that further proceeding of the said title suit number 152/2022 may be stayed. The submission of Mr. Khondokar needs further consideration at this stage. Notice be issued to the respondent returnable in, we'll fix 2 weeks time. 2 weeks. Step upon the respondent be taken by registered post, or speed post, and also by usual process within a week from today. List after 4 weeks. Though Mr. Khondokar price for staying further proceeding of the title suit number 152 of 2022, it is provided that the amendment so affected by so allowed by the learned trial court by the impugned order dated 5/1/2026 shall be subject to the outcome of this civil revision petition. Let's the matter after 2 weeks.
I am deeply impressed.
So do I allow justice service?
My lord, register as well as usual process.
Okay.
Not necessary. After 4 weeks, 4 weeks or
2 weeks.
2 weeks. I am deeply.
Orders?
May I pleasure, Lordship?
Yes.
I may be given 1 day time because due to some reasons it was not taken. For taking step, my lord. Within 7 days I used to take. Today itself I'll take.
Okay. Heard Mr. C. Borua, learned counsel for the
Petitioner.
petitioner. Mr. Borua submits that due to inadvertence, he could not take step upon the responsibility. And he will take step upon the respondent today itself. Accordingly, it is provided that recess shall list the matter after
Maybe 2 weeks because.
2 weeks.
Yeah.
After 2 weeks. After 2 weeks by speed post and also by usual process. Office note dated 24/2/2026 also indicates that LCR has already been scanned. Copy of the TCR has already been received. List the matter after 2 weeks.
Fine. Obliged.
Number 4.
Today I filed Wakalana on behalf of sole respondent.
Respondent,
Sole respondent.
sole respondent.
Service is complete.
Okay. Heard Mr. Ganguly, learned counsel for the appellant, and Mr.
K.T. Sharma.
K.
K.D. Sharma.
K.D. Sharma, learned counsel for the respondent. Mr. Ganguly submits that this matter service is completed and matter may be listed for hearing.
Lordship.
LCR has been received?
But LCR was called for, I believe, but whether it's received, cause this
Received.
does not indicate. I'm told it has come. Madam.
Okay. Office note dated 24/2/2026 indicates that LCR from the learned trial court and also from the learned first appellate court has been received. Accordingly, it is provided that recessal list the matter for hearing in usual course, 25 matter.
But in light of that order, my lord, perhaps the IA can be disposed of, making the stay of the execution process absolute till the disposal of the main appeal.
Yes.
So since the appeal has been admitted for hearing, my lord.
Not today, Lord.
No, why not today, my lord? Today is a very auspicious day.
Today,
My
not
lord,
today, Lord.
the appeal has been admitted for hearing. IA, why should it be kept pending, my lord? That is my humble submission. This is a fruitless exercise.
Any day next week, Lord, can that may this problem.
Next day.
Next week, Lord, not today, Lord.
Okay.
Next
Heard
week,
Mr. Ganguly, learned counsel for the applicant, and Mr. K.D. Sharma, learned counsel for the respondent. List this matter along with RSA number 2.
well, let it come after the 12th, my lord. 12th of March.
218 of 2025. 2/1/2025. After
After the 12th, my lord. 12th of March. My lord. I have some difficulties.
this, I when?
18 or 17, Lord.
17th.
18th of March.
No, the IA then will come up for orders, I believe.
Yes.
Orders. Obliged, my lord. No, there's an interim order in the IA that may extend it. The
Interim
stay of the
order?
execution, yes.
Interim order is there.
Yes, ma'am. That is why, my lord. That is why I suggested that since the appeal has been admitted for hearing, my lord, the IA, my lord, cannot be, otherwise it will become infructuous. The stay of the execution process.
Okay. So already stay has been granted. What purpose will be served?
Let it,
Let us
let it come up, my lord, for hearing, and on that day, my lord, the matter will be decided. It's otherwise not a very complicated issue.
yeah, since stay has already been granted, we will extend it till disposal of this RSA. We will extend it till disposal of the RSA.
Lord.
Good.
Follow line. Cut it here. Mr. Ganguly, learned counsel for the applicant, submits that by order dated 15/12/2025, while admitting the RSA, this court was pleased to grant stay of execution. The stay of further proceeding of title execution number 52 of 2025 till returnable date. And since the respondent are represented by their counsel, the same may be extended till disposal of the appeal. Accordingly, taking note of the submission of Mr. Ganguly, learned counsel for the appellant, and also Mr. Sharma, learned counsel for the respondent, opposite party, the interim order dated 15/12/2025 stands extended till disposal of the RSA. In terms of this, IA stands disposal.
Good. Keep the
Usual course, 25 meter.
25. Published.
No.
May please your lordship. Lordship, may kindly peruse the office note dated 24/2026. Lord, in respect to one Gaur, my lord, answer of notice is awaited. In respect to my lord, notices and one sir and one chair, my lord, I may be granted the liberty to take steps upon the, my lord, the new address, my lord. I have submitted steps, but in the new address.
You are for
Very on behalf of respondent two.
respondent number 2.
Yes.
Heard Mr. BP Sinha, learned NBP Sinha, learned counsel for the applicant. And Miss, your name please?
P. Sharma.
B.
P. Sharma.
Sharma, learned counsel for the respondent number 2. Office note dated 24/2/2026 indicates that neither unserved notice nor ID card in respect of the notice issued to the respondent number 1, Ungo, return till date. And the said office note also indicates that no notice was issued to the respondent number 1 so and 1 so. You have to take step upon all the respondents.
My lord,
There's a-
regarding one Ungo, my lord,
1 Ungo,
my lord, it is awaited, my lord. But in respect to one saw and chaw, my lord, I have to take, my lord, because I have submitted steps upon a new address, my lord. So that is why, my lord, registry told me that I have to take leave of this honorable court to take steps upon the, my lord, new address. Regarding one saw and one chaw, my lord, I have to take steps. One Ungo I have already
Okay.
taken, my lord.
Justice shall list the matter after 4 weeks, awaiting service report upon 1 Ungo. Mr. Sinha further submits that he may be granted liberty to take step upon the respondent number 1 so and 1 so in their new address.
Yes, ma'am.
In their new address. We are allowed step be taken by speed post and also by usual process within a week from today. List the matter after 4 weeks.
Obliged. Deeply, please.
Item 6.
It is your lordship.
Hmm.
Lordship, the appeal has been admitted, my lord, but the stay has not been granted.
Hmm.
On the earlier occasion, I had pressed for the stay, my lord,
Hmm.
but the other respondent has appeared and they had sought time to file their objection.
RSA is admitted.
Yes, my lord. SQL has been framed, my lord.
Yes, Mr. Mishra.
Written by the civil stay is that, my lord, they will become homeless. The ground in the stay application is this, my lord. If this judgment is not stayed, my lord, and if they might be evicted from the home, my lord. My lord,
Their execution case has been filed.
Yes, my lord.
Filed.
File, my lord.
That's one, my lord. Who is explained here, my lord. In her cross, he is admitted, my lord, and she has her own lane, my lord.
No. We will consider the case on merit on next date at the time of hearing. But since the appeal has been admitted, let the proceeding be stayed.
That's true. That is true.
Heard Mr. K.R. Barua, learned counsel for the petitioner, applicant, and also heard Mr. Mishra, learned counsel for the respondent, opposite party. This application under Order 41, Rule 5, read with Section 151 of the Code of Civil Procedure is preferred by the applicant for staying operation of the judgment and order dated 22/8/2025 passed by the learned civil judge senior division Dibrugarh in title appeal number 10 of 2022. It is to be noted here that by the impugned judgment and order dated so and so, the learned civil judge senior division Dibrugarh has affirmed the judgment and decree dated 4/7/2022 passed by the learned Munsif number 1 Dibrugarh in title suit number 6 of 2016, whereby the suit filed by the respondent struck plaintiff was decreed. Mr. Borua submits that the appeal has already been admitted for hearing after framing of substantial question of law. The record has also been called for. And in the meantime, the respondent herein have already initiated execution proceeding, being execution case number
25/2025.
25/2025. And as such, there is a requirement of staying operation of the impugned judgment and order dated 22/8/2025 passed by the learned civil judge senior division Dibrugarh in title appeal number 10 of 2020. Mr. Mishra submits that he has no objection in the event of staying operation of the impugned judgment and order since the appeal has already been admitted. Accordingly, taking note of the submission of learned counsel for both the parties, operation of the judgment and order dated 22/8/2025 passed by the learned civil judge senior division Dibrugarh stands state till disposal of the RSA number 201 of 2025.
Only one thing, my lord. My no objection may not be recorded, my no objection, my lord.
Okay, okay.
Lord,
How oppose the petition?
I have objection, lord, may record the objection.
However, পিছত লগাই দিলে হ'ল। However,
My problem.
Obligation.
7.
এইকেইডাল ইমান ওচৰত দিয়ে বৰ দিগদাৰ পাওঁ। আৰু হেৰিয়াত লাগিলে শব্দ এটা হয় ন। এইটো ভাল নহয় নেকি?
May it be please, Lordship,
Yes,
as per direction of the court, we have taken steps within 7 days. And as per the last office note, neither ID card nor answer notice is received. Let the notice be served upon respondent.
okay, we'll fix after 2 weeks. Awaiting service report.
The 4 weeks.
Okay. Pardon me, sir.
Uh,
Your
And
name?
My name is Deputy Secretary.
Learned counsel for the petitioner. Office note dated 24/2/2026 indicates that neither ID card nor answer notice issued to the respondent returned till date. Accordingly, it is provided that RSS shall list the matter after 2 weeks awaiting service report upon the respondent. Further, it is provided that RSS shall track the consignment and put up an up-to-date office note in respect of delivery of the notice to the respondent, which was sent, no, which was issued earlier by way of speed post. List after 2 weeks.
Number 8.
May it, Lordship. Lord, sorry, my lord, I could not follow the office note, my lord. I have taken steps on the on 30th of my lord January.
You have taken a step.
Lordship.
Pardon me, sir.
M. Ali, my lord.
M. Ali, learned counsel for the petitioner. Mr. Ali submits that he has taken step upon the respondent only on 24th. 24/2.
No, my lord. 30/01, my lord. 30th of January, my lord.
No, 38th of January, court order was passed.
The lordship, sir. But I could not check the office note, my lord.
No, that's all right. On which date you have taken a step?
On 30th, my lord.
Okay. Taken a step upon the respondent on 30/1/2026. Accordingly, it is provided that RSS shall list the matter after 2 weeks awaiting service report upon the respondent.
There is an interim order, my lord.
Interim order passed earlier shall complete.
One thing, my lord, the respondent number 1, my lord, I have wrongly arrayed, my lord.
PP.
PP, my lord. It's a civil matter, my lord. It has been wrongly.
Okay.
It may be omitted.
Okay. The learned counsel for the petitioner has pointed out that in this matter, learned PP is shown in the cause list for the respondent. But PP has nothing to do with this matter. And he submits that rest may be directed to delete the name of the PP from the cause list. Fair allowed, rest shall do the needful in this regard.
Okay.
Obliged.
Item for assumption, item number 1.
Lord, kindly peruse the order dated 15/12/2025. Hearing has already taken place on 9th December.
Lordship, we are supposed the speaking order will be released within few days, Lordship. Lordship, sometime we will launch it, Lordship.
Within
Hearing has
few
been
days.
completed, Lordship.
So 9/12 means already 2 months elapsed. More than 2 months.
My lord.
Between previous law.
Heard Mr. Khan, learned counsel for the petitioner, and Ms. R. Barua, learned
Standing from the secondary education department.
standing counsel for the secondary education department.
Response 150.
Ms. Barua submits that speaking order will be passed shortly. And she prays for listing the matter after 1 week.
Lordship. 2 weeks, Lordship. Lordship, this
After 2 weeks, pair allowed, recess the matter on fixed date.
16.
16th of March.
Bench to matter, Lordship. Lordship,
No.
we come before it.
No. Already that had.
Huh?
That had.
Partner?
Oh, yes.
Partner.
Hey, partner. Partner.
Partner matter, Lordship, may we come before it.
No. Partner only has a.
No, you go to the registry. We will not pass any such order.
Partner.
Obliged.
Items for hearing, item number 9 by BC Moore.
Please, Your Lordship. Your Lordship, am I audible?
Yes.
Please, Your Lordship. Your Lordship, actually, I'm engaged in this matter a few days back, and actually, I'm in Delhi, so I have to come all there from Delhi only, and the date was not confirmed on the last date. That's why I couldn't be there physically, Your Lordship. Actually, Your Lordship, in this matter, we have to file an application for framing additional substantial question of law. So for the same, Your Lordship, I need some time at least. Please kindly give a week's time, Your Lordship, for filing this application. Hello.
Heard, madam, your good name, please.
Advocate Monica Singh, Your Lordship.
I'm saying learned counsel for the appellant, and also heard Mr.
T. Gogoi, Your Lordship.
D. Gogoi, learned counsel for the respondent. Ms. Singh submits that she may be granted some time to file an application for framing additional substantial question of law. Pair allowed, recess the matter. After 2 weeks,
Your Lordship, after 1 week, maybe.
1 week. Okay, all right. After 1 week. Next
Your
item.
Lordship, it will be grateful if the date should fixed any date after 1 week, Your Lordship.
On 10th March.
10th of March.
10th of March. Much obliged, Your Lordship.
Item number 10.
May I please, your Lordship? Lordship, matter kindly pass over for a time being, Lordship. Senior is election court number 1, Lordship.
Who is your senior?
OP Bhati, Lordship.
Okay.
Item 11.
Please, Your Lordship.
Mm.
Lordship, we need some time, at least 2 weeks' time to do the hearing. Suddenly it came up, Your Lordship, so we couldn't prepare it.
Suddenly came up.
Appearing-
It is a 24 matter.
Yes,
How
Your
suddenly
Lordship.
came up?
Lordship, also yesterday we received a call that one of the appellants have perhaps expired. We have the death certificate, it is not clear.
Okay.
So we'll have to identify whether substitution requires to be done or not.
Okay. Heard, Mr. Your name, please?
M. Shah appearing for SC Biswas.
Learned counsel appearing for the appellant.
Appellant.
And Mr. Talukdar for?
Yes, I am the final.
I. Talukdar, learned counsel for the respondent.
Yes.
Respondent. The learned counsel for the appellant submits that as per his information, one of the appellants suffered demise, and he will take instruction as to whether implement of the legal heirs of the said appellant will be required or not. And he prays for listing the matter after 2 weeks.
Yes, sure.
Pair allowed, recessal list the matter after 2 weeks.
My lord, I create the indulgence of your lordship. Since there are in the appeal, my memo, my lord, there are 10 appellants are there. Number 1 appellant is a mother. And the number 2 to 10 are the son and daughters of the appellant number 1. So there is no need for substitution of other inheritors of legal heir.
Okay,
No,
let them obtain
confirm it, that's
instruction.
why, my lord. Otherwise, we can argue the matter after 2 weeks, my lord.
Okay.
Final hearing.
Okay.
Yes.
The date may be fixed, my lord.
Okay.
It's very difficult to list.
Date may be fixed,
24th March.
24th.
Matter number 13. Order matters.
Okay, counsel for the respondent, Mr. M. Talukdar. Wait for some time.
Okay.
Item 14.
Problem আছে আজি টাইপিং কৰোঁ তেতিয়া চাৰৰ প্ৰব্লেম আছে লৰ্ডশ্বিপ joint pair lordship we have paid for time lordship time lordship accommodation for today's accommodation joint pair lordship
Heard, Mr.
jam gogol lordship on behalf of BD Goswami lordship
J.M. Gogoi, learned counsel appearing on behalf of Mr. B.D. Goswami and also heard Miss
E. Devi, I am appearing for respondent.
E. Devi, learned counsel appearing for the respondent. Learned counsel for both the parties prays for listing the matter after
19 March, lordship.
on 19th of March.
92.
Fair allow.
Item 15.
obli
You have made a mention in the morning
Yes.
for adjournment, lordship. Did well, Mr. El Talukdar, lordship, in this matter. He has not been able to come today.
Mr. Your name,
A.
please.
Bhattacharjee, lordship. A. Bhattacharjee,
A. Bhatta says a learned counsel appearing on behalf of
the appellant.
learned counsel for the appellant. None appears for the respondent on call. Mr. Bhatta says a price for listing the matter after
Lordship, after view vacation.
BU vacation. Pair allowed, recessal list the matter after BU vacation.
Lordship.
Item 16.
Please, your lordship.
Yes.
Facts of the case, my lord. The petitioner is before your lordship, my lord, against the order of the title suit, my lord, which your lordship will find, my lord, at page 53, my lord, Annexure 7, my lord. What happened, my lord, in a trial case, my lord? Title suit, my lord, filed by the defendant, my lord. At the point of, my lord, examination, evidence of chief, my lord, of the plaintiff, my lord. On the earlier date, my lord, the plaintiff has submitted the,
You show me the order.
it is in page 53, my lord, Annexure 7, my lord.
Page number 50.
53, my lord, Annexure 7.
You are for the
I am for the
Defendant.
defendant in the
Defendant.
trial case, my lord.
Mm.
He is for the plaintiff,
No, is there any bar?
my lord. The petition, my lord, the lordship will see at page, my lord, 39, Annexure 4. The petition was filed under the,
No, you tell me, without submitting the evidence of other PWs,
yes, my lord.
is there any bar in cross-examination of the plaintiff's witness number
Other
one?
plaintiff, my lord. My lord, as per, my lord, the Indian Evidence Act, my lord, on the other 135, section 135, my lord, the procedure of examination of witnesses, my lord. One 138, my lord, section 138, my lord. Order of examination, my lord. Order of examination. Witnesses shall be first examined in shift, then cross-examine, and then if the party calling him so desires, re-examine. So witnesses, all the witnesses have to be first, my lord, examined in shift, or in this, my lord, they have to submit all the evidence on affidavit of all the prosecution witnesses, my lord. Before, my lord, the cross-examination starts, my lord.
Where it is provided that all the witnesses should be examined in shift?
It is, my lord, witnesses, my lord, all the witnesses, not witness. Starts from, my lord, witnesses shall be first examined in shift, my lord.
No, in a particular case, there may be several witnesses.
My lord.
So therefore, this word witnesses is mentioned in plural form.
Also, my lord, in my lord CPC, my lord, under my lord order, my lord. Order 18, my lord.
Order 18. Yes. Rule?
Rule 4, my lord. Recording of evidence, my lord. In every case, the examination chief of a witness shall be on affidavit, and copies thereof shall be supplied to the opposite party by the party who calls him for evidence, my lord. Without, my lord, furnishing all the evidence on affidavit.
No, no, you tell me, is it the language of this section?
My lord.
All the witnesses has to be furnished? Is it provided?
In every case, the examination chief of a witness shall be on affidavit and copies thereof shall be.
Witnesses, this is singular. Not
Thereafter, my lord, 1A, my lord, the affidavit of evidence of all witnesses whose evidence is proposed to be laid by a party shall be filed simultaneously by the party at the time directed by the first case management hearing.
Which part you are reading?
My lord, after provided, my lord, in italics, my lord, 1A, my lord.
That is the special amendment.
My lord.
That is in respect of commercial dispute, 1A.
My lord, what happens, my lord, if, my lord, cross-examination is allowed before all the witnesses have submitted their evidence and affidavit, my lord,
Mm.
he will be able to fill up his lacuna, my lord. That is why, my lord, it has been, my lord, I think it should be not be
No,
applicable, my lord.
that's all right. But is it provided in the act or in the acts? Either in evidence act
In
or
my
in
CPC, my lord, it is has the process of examination of witness, my lord, it is
so
has been
this
left to the
one
discretion,
A is in respect of commercial suit.
my lord. Under, my lord, order 18, my lord, right to begin, the plaintiff has a right to begin unless and the discretion has been left to the court, my lord. But the process that is, my lord, generally adopted, my lord.
The trial court,
Evidence or
if
affidavit.
the trial court has exercised its jurisdiction in a particular way, can this court sitting in revision petition substitute its own view
My
with
lord,
that of the trial court?
because the petition, my lord, it has been filed under the trial court and Gauhati under the Gauhati High Court rules, my lord. The petition they have filed for allowing this, my lord.
Is it provided in the Gauhati High Court rules?
Guwahati High Court rules, my lord, under the lordship will
Civil
kindly
court
see.
rules and practice.
It is, my lord, trial court and first appellate subordinate courts under the Guwahati High Court case management rule 2007, my lord. It is annexed in the petition, my lord.
Page 43.
Page 43.
It starts from page 43, my lord. Relevant portion.
47.
Last. If the parties are not.
If the parties are not keen about settlement, the court shall frame the issues and direct the plaintiff to start examining his witnesses. The procedure of each witness filing his examination sheet and being examining cross or re-examine will continue one after the another. But this one after the another, my lord, it has been, my lord, misrepresented that one witness will come, he will file his cross-examining evidence. Then I'll cross-examine him and the next witness will come. But in this process, my lord, he will be able to fill up his lacuna, my lord. That is why, my lord.
No, that's all right, but nowhere it is provided that all the witnesses, evidence, examination in chief of all the witnesses are to be filed in one go.
My lord, it is not provided.
Then it is also not provided here. You show me any provision which requires filing of evidence, no, filing of examination in chief all the witnesses together. Show me any decision of
In that
any
case,
court.
lordship may take it after, my lord, holy vacation, my lord. I'll
After?
submit after holy vacation, my lord. I'll submit some judgment on, my lord. This act will take precedence over the rules, my lord.
Yes. No, that's why my question is whether it is provided in the act.
It's not provided in the act, my lord.
Then?
In the act, my lord, it has been left to the discretion of the court, my lord.
Then?
And as a procedure that is followed, my lord, it is left to the discretion of the court.
No, procedure must be provided in the act itself. If it is not provided in the CPC, then Mhm. Mr. Islam, what is your stand here?
Rightly passed the charter here. Rightly passed your page 47 that is that petition filed under that rule, High Court rule. And the procedure of each witness, I think is exemption C. And being examined in close or re-examined, exam continue one after another. That means after completion of one, then next weekend.
After examination of the number one, then number
Then
two.
Yes, thank you, sir. The procedure of each witness filing his exception sheet and being examined in cross or re-examined
Mm.
will continue one after another.
Mm.
That means one witness period, then next one. That's rightly passed.
Okay, we'll list the matter after vacation. You come prepared.
The holy vacation, my lord.
Okay. Heard Mr. Parasar.
Yes, Parasar.
Yes, Parasar, learned counsel for the petitioner, and Mr. Islam for the respondent. Heard in court, list the matter on
6.
short date. 10.
Okay.
10.
All right, man.
17.
May I please, Your Lordship? Well, a petitioner before Your Lordship, represented by its headmaster, and the school is a provincial school. A plot of land belonging to the school, that is vacant land, and used to give in tenant for cultivation. Accordingly, the respondents were engaged as a tenant cultivator, and after some days they are now preparing to grab the land permanently. Thereafter they were replaced, and accordingly they will come before the court and institute a title suit for declaration of possessory right, title, interest. Well, this is the case before Your Lordship. In this case, injunction was granted by the trial court. Accordingly, appeal was preferred. And appellate court also upheld the same. Accordingly, we preferred this revision before this honorable court. And upon motion, honorable court was pleased to stay the temporary injunction order. And thereafter, they have filed a vacating petition that was also disposed of by this honorable court. And today is before Your Lordship is a final hearing, my lord. My lord, admittedly, they were tenant agriculturists, and the school is under state government. The land is belonging to the provincial school. Ultimately, it is a case, the tenants were the under state government. As per definition of the Tenancy Act, they were even not tenant also. So under what basis they are claiming their right, title, interest? This is the disputed fact. So we are before honorable court trying to draw attention of the honorable court that under what right they are claiming their right, right, title, and interest, possessory right, title, interest. So before entering to the facts, just I am drawing attention of the honorable court. The definition of Assam Temporary Settlers Tenancy Act 1971. Section 3, subsection 17. There is proviso. Just I will read out. Proviso is there, provided that a person who cultivates or holds land immediately under the state government.
You are reading Assam Tenancy?
Lordship, Assam Temporary Settled Areas Tenancy Act 1971. Just I am reading, my lord.
Pause for a moment. They are trying.
Section 3, definition section, okay. Subsection 17, my lord. That is tenant. And last part is my lord proviso. that proviso mentioned that a person who cultivates or holds land immediately under the state government is not a tenant within the meaning of this definition. So, my lord, admittedly, they were, my lord, tenant cultivators. So, as per the definition, they are not even tenant also. So, my lord, we are trying to argue before this honorable court that under what basis they are, my lord, claiming right title interest. On the other hand, the case before my lord, the plaintiff instituted before the trial court is under fraudulent. Why this question arises before this my lord, why this question arises while trying to satisfy the honorable court, my lord? My lord, before instituting the title suit, earlier they were approached this honorable court with a writ petition. In that writ petition, honorable court has been disposed of the matter and made some observation, my lord. Just I would like to refer the page. Page 43 onwards. Relevant page 47. And these matter also suppressed before the trial court regarding these proceedings. Read proceeding. Page 47 is the relevant page, my lord. May I read, my lord? Second paragraph. This writ petition has been filed by the petitioners. Well, 11 petitioners were there, writ petitioner. Seeking a direction to the respondent authorities to allot a plot of land measuring 6 bighas, 1 katha, 9 lesas located at village number 3, Kolondikah, under Dolgao Revenue Circle, Dorong, covered by DAG number 44, to them considering their long possession and also they being the landless persons. The petitioners have further prayed to declare illegal, null and void the show cause notices issued to them by the respondent number 6, asking them to vacate from the land in question. Insofar as the first prayer of the petitioners in this writ petition is concerned, if they are entitled to be allotted the land mentioned herein above, they may approach the competent authority for allotment of the aforesaid land. Insofar as the second prayer of the petitioner in the instant writ petition is concerned, Mr. A.U. Ahmed, Learned Counsel, representing the respondent number 6, has produced a copy of the letter dated 8/12/2022, written to the Senior Standing Counsel, Secondary Education Department, Gauhati High Court, by Mrs. Monica Borgohai, ACS in charge, Inspector of Schools, Dorong District Circle, Mongol Divide Memo number so in connection with the instant writ petition, whereby it has been recorded that the land mentioned by the petitioner herein belongs to Korifuguri High School. Well, this is the government communication to the Honorable High Court. Accordingly, the second prayer made by the petitioners in this petition appears to be a civil dispute between the parties. In view of the above, this writ petition is hereby disposed of with liberty granted to the petitioners to approach the competent authority for allotment of land under their occupation, and also to approach the appropriate forum for resolving the land dispute between them and the respondents number 6 and 7, if so advised. The copy of the letter dated so written to the Senior Standing Counsel, Secondary Education Department, Gauhati High Court, by Mrs. Monica Borgohai, so and so, so and so. This is the order passed in writ petition filed by the respondent. Now, question is that here is 11 numbers of writ petitioners were there. Now, plaint has been instituted, title suit has been instituted by eight persons. Out of 11, 8 persons are before the trial court filed this title suit. What about the other 3 persons? And one new person is coming, entered in this title suit. So entire proceeding is under fraudulent, and they are trying to somehow to grab the land of the school running under the state government. So this is the case under fraudulent. And in regard to the case of under fraudulent, Honorable Apex Court is very much clear. Honorable Court also aware. Just I am pointing out. Just I read out a line, my lord. The principle of finality of litigation cannot be praised to the extent of such absurdity that it becomes an engine of fraud in the hands of dishonest litigant. The courts of law are meant for imparting justice between the parties. One who comes to the court must come with clean hands. A person whose case is based on falsehood has no right to approach the court. He can be summarily thrown out at any stage of the litigation. A judgment or decree obtained by applying fraud on the court is a nullity and non-ist in the eyes of law. Such a judgment decree by the first court, by the highest court, has to be treated as nullity by every court, whether is superior or inferior. It can be challenged in any court, even in collateral proceedings. This is one judgment we are going to rely upon. Just I will summarize this case. Now, on record, what is the disputed land status? Lordship, page 30. Kindly have a look. Page 30 only.
Yes.
As per the resolution number 94 of the meeting of the Land Advisory Committee of Udalguri subdivision held on 31/12/1993, the land measuring 3 bighas, 4 kathas, 1 lesses of Dag number 83 and 84.
Paragraph number, you were reading paragraph number?
Lordship 30. 30. 30 under fault, my lord. Page may be under fault.
Okay.
Lordship.
Yes.
As per the resolution number 94 of the meeting of the Land Advisory Committee of Udalguri subdivision held on 31/12/1993, the land measuring 3 bighas, 4 kathas, 1 lesses of Dag number 83 and 84, 2 number Kwari Pukri village under Mauja Dolgaon, and 6 bigha, 1 katha, 9 lesser. This is the disputed land, my lord. 6 bigha, 1 katha, 9 lesser of Dag number 44 of village 3 number Golondika under said Mauja, total 10 bighas, 10 lessers has approved in the name of Kwari Pukri Siddiqia Senior Madrasa. But this was the school, earlier it was board of Madrasa board. Thereafter it was converted to high school. Now it is under secondary director of secondary education, my lord. And this is the land, my lord, mutated in the name of the school. And my lord, in title suit, performer defendant made in the title suit, state government made performer defendant. Accordingly, my lord, circle officer entered their appearance by filing written statement, and one certificate has been issued by the circle officer. Kindly have a look, my lord, page 33. Page 33, my lord, the land herein. This is to certify that the Kwari Pukri Senior Madrasa is situated under the 2 number Kwari Pukri, Gaon of West Dolgaon, Mauja, Dolgaon Revenue Circle. The 2 number Kwari Pukri is fall under the general area of Dorong district outside of BTD area. Name of the institution so-and-so, circle office so-and-so, Mauja, village, Dag number. Total land 10 bigha, 10 lesser. This is the school land, my lord. And dispute land here is mentioned, column 5, my lord. 6 bigha, 1 katha, 9 lesser under Dag number 44. Circle officer certified like that. This is on record, my lord. Now, my lord, would like to refer the written statement filed by the circle officer, 85, page number 85, my lord. '85 onwards, relevant page was 86. By way of this written statement, my lord, categorically denied the all averments made by the my lord respondents plaintiff. The pro defendant number 3 submits the written statement for his own and on behalf of pro defendant number 1 and 2 are as follows. My lord, 1 and 2 represented my state, lordship. that the suit is not maintained in the present form, that there is no cause of action for filing this suit against the answering pro-defendant, as such the same is liable to be dismissed. That the present suit and particulars set out are too vague and also bad for material subtraction and not non-disclosure of material facts as required law. That the suit is bad for non-joinder so and so, that serves and accept, that is specially admits so and so, my lord, has no locus standi to institute the suit against the answering pro-defendant, as such the same is liable to be dismissed. That the average pro-defendant has no comment in respect so and so, but it is not true that the plaintiff and the Akbar Ali and some other since last 40 years used to cultivate different types of crops over aforesaid. But they are categorically denied by the circle officer. Paragraph 12, my lord, here is mentioned that the issues made in first part of the para 8 of the plaint are related to matter of records of revenue authority, but it is denied that the plaintiff is to reside and cultivate different types of sources. So, my lord, so far, my lord, our understanding, they have no locus to file, my lord, the title suit. On what basis they instituted this case? Now the case of the trial stays is well documents. They are not cooperating with the honorable court, the court below, to produce the document and not even frame the issues also. But here they are interested to proceed with the ballot only.
Where is the impugned order?
Mine.
Page number?
Yes, sir. Page number 90, your lordship. Absolutely, it is suffered from legality, propriety, and correctness, my lord. Decision and results thereof, page 95, my lord. Page 95. Got it, my lord?
Yes.
I have perused the documents appended with the petition and written objection by both sides and have also gone through the case record. Before coming to the merits of the facts and circumstances of the case portrayed by either party, I would first like to discuss briefly the parameters that bind an injunction hearing and the scope of an order of temporary injunction. The primary object in interlocutory injunction is to protect the party against injury by violation of his right for which he could not be adequately compensated in damages recoverable in the action if the uncertainty were resolved in his favor at the trial. This view was reiterated by the Honorable Supreme Court in case so and so so. So they discussed some case law, but our case is very identical. And what right there? As tenant, they are tenant, tenant cultivator. As per the definitions, they are not tenant also. So under what right they are instituted this case? So both of the landed courts might have overlooked the same. So that's why we are before just for interference in the interest of justice. The principle discussed here. Additionally, it is a well settled precedent that while deciding a prayer for the grant of temporary, three factors. Three factors will, so for our instance, the first principle is not even met by the respondent plaintiff. Therefore, while disposing of the prayer for the interim injunction, I shall reserve to adjudicate the matter by laying emphasis on the facts of the case in reference to the three parameters that guide an injunction proceeding. Existence of prima facie case. If we bring our focus onto the averments put forth in the petition and the submission made on behalf of the petitioners, we see that they had specifically asserted their possessory right over 10 different plots of land described in 10 schedules. Totally vague schedule has been given before the trial court. right over 10 different plots of land described in 10 schedules and covered by the total area described in Schedule A of the petition, which has allegedly been in their possession for the last 50-60 years. Last 50-60 years, in support of what documents they have been filed before this court? Well, in this, before this honorable court also, what documents they are relying upon their possessing since 1950-60 years. The claim of the petition, so like this perverse, suffers from perversity. The claim of the petitioner have been denied by the opposite party who has challenged the rights on the ground that 5 acres of the total land were given to the petitioner for permissive occupation by them on the yearly thika basis since the 1960s, and they had run the Quarry Pukuri Kharejia Madrasa, that is the Quarry Pukuri High School A, now from the payment received from those permissive occupiers. Thus, we see that a clear dispute has arisen between them and respect to their rights over the Schedule A suit land. Moreover, considering the matters on record, it is yet unclear as to which of the parties involved have any subsisting legal claim over the disputed plots of land. This fact shall be addressed and taken up during the course of. But here, page number 97, paragraph 10, I am reading, Lordship. It is yet unclear as to which of the parties involved have any subsisting legal claim. It is very much clear that one provincial is a school. Land is belonging to a provincial school, or the land is already mutated on record. Thereafter, also this kind of finding, how much it will be acceptable, Lordship. It is yet unclear as to which of the parties involved have any such legal claim over the plots of land. Why the school cannot claim the legal? Why school has no legal claim? The government, provincial school running under the state government, the land, ultimately under the state government. Under what right they are claiming, Lordship? This fact shall be addressed and taken up during the course of the trial, where each party shall be given an opportunity to put forth all necessary evidence to prove their stance. This considering all the above observations, I am of the opinion that a prima facie case does exist between the two parties, and there are certain rights and liabilities of each party that need to be adjudicated upon and shall be decided at the end of the trial of the main suit. Balance of convenience. Well, these are the discussion of the landed court below, Lordship. The factum of the possession of the suit land currently being in the hands of the petitioners have petitioners have possession in this case, as because they plain itself reflecting that they are not in possession. They made party the present cultivators, though newly engaged by the school authority. Defendants here: Mohammad Taib Ali, Abdul Aziz, Abdul Hashem, Khadem Ali, Saiful Islam, Shah Ali, Aher Ali, Hanim Ali. These are the new sets of tenant cultivators. But court, under landed trial courts, mentioned that the petitioners have not been denied by the opposite parties who have simply alleged that they were their permissive occupiers only, and as such do not have any right to apply for allotment of the plots of land, including the total land described in Schedule A of the petition. They had, however, asserted that the suit land is no longer government land, as it had been mutated in favor of the Quarry Pukuri High School A in the year 1999. However, the opposite parties have not submitted any documents in support of their contention, while the petitioner herein have submitted the photocopies of several documents which shows that different plots of land described under so and so have been under their possession since a long time. Only the nature of their possession over the said suit land is under dispute in the main suit. The petitioner have brought the present prayer for injunction on the primary ground that the opposite parties had attempted to dispossess them from the Schedule A to A10 suit land. They have prayed for relief, stating that the opposite parties are required to be restrained from following through with such plans, as it would cause irreparable loss to them if they are forced out of the suit land during the pendency of the trial and before they are able to prove their rights over the same. The opposite parties have denied such allegations of such illegal activities on their part, but have not raised any specific objection against the claim of the petitioner that they are currently in possession of the suit property, which had admittedly handed over in contractual basis. Fine.
Yes, Mr. Mahmood. You see, in the paragraph number 7 of the plaint,
Yes.
you have mentioned that the scheduled land is a government khas land.
Yes.
And the government Has the absolute right, title and interest? What right, title and interest you are having over the aforesaid plot of land?
Actually, my learned friend has argued the main case.
No, you, please answer my question. It is from your plaint, it appears that it is a government land.
Government. No, government land, but.
How you have accrued your right, title and interest over the same?
Kindly see page 49.
Mm.
There are 2
Mm.
and 3.
Mm.
The plaintiffs are poor contributors and they used to maintain the livelihood by doing cultivation
Mm.
and labor, and all the plaintiffs are poor person living below the poverty line.
But the Mr. Mahmood, you say the certificate of the circle officer
Yes.
indicates that over the said plot of land, one madrasa is running.
Madrasa was there, and that madrasa gave us to stay there as tenant or permissive possessor at that time. Now the land is, as per certificate of the circle officer, it appears that it is government land, and it has been allotted in the name of the
School, madrasa.
Now madrasa that are converted into school.
School, okay.
Now Lordship may kindly see page 55.
Mm.
There are 8.
Mm.
That the plot of land measuring an area of 6 bighas is situated under site number 44, which is situated at number 3 Gauhati Kash under Paschim Dolgaon Moja of Dolgaon Revenue Circle, and over the aforesaid 6 bighas of land, the plaintiff used to reside and cultivate different types of crops since last 50 to 60 years. So Lordship, here the question is whether the land is patta land or land is caste land, or we are in possession of the
No,
land.
you first tell me how prima facie case is made out in your favor.
Well, a prima facie case in this sense, but it is the injunction matter. The learned munshi passed order in our favor. Consider this, well, I also say that IA number 169, that may be treated as the WS in this case.
That is already disposed of, my lord. IA has been disposed.
Disposed of, but the matter.
The main petition, they have not filed any objection.
No, objection does not mean because our house is there. My lord, we kindly consider our house is there. We are living there along with our family members dwelling by constructing dwelling houses. And it is not constructed today. It has been constructed since the 50, 60 years back. At that time, nobody raised the objection. So the Honorable Court below.
No, maybe. You, in the paragraph number 7 of the plaint, you have admitted that it is the government land.
At that time, at present, my lord, case suit is filed just in the year, a suit is filed in the year 2023. But we are in possession of the land since last 50 to 60 years. And we have constructed dwelling house, living there along with our children, etc. So the court found that the balance of convenience is in their favor. Now,
Maybe if a prima facie case is not there, even if balance of convenience is there, whether injunction can be granted.
But the prima facie case is there. The court found that, but it is concurrent finding are in your favor. Now, Lordship would say the decision of the honorable courts that regarding injunction matter, court should be very slow, or court should not interfere because there are 2 concurrent findings in our favor. If further
Maybe,
injunction is granted,
Mr. Mahmood, though two concurrent findings are there in your favor, this is not a second appeal. And those findings are not binding upon this court.
no,
This is a CRP.
my lord, order of the Supreme Court, my lord, is binding upon all courts, including the High Court.
No, that's all right. That is only in respect of regular second appeal, not in case of CRP.
We are on injunction, my lord. Our courts.
Yes, that is a CRP.
We are on injunction, we will submit the law files on injunction.
You say this is civil revision petition. We will only examine the legality, propriety, and correctness of the impugned order.
No, that cannot be done perhaps in this subject to correction. Kindly say, we have given the judgments also. I am reading the operative portion. This is first one in 2004, 1 GLT 210. Suresh Kumar Dhanuka versus Kedarnath Dhanuka. No revision petition under section 115 CPC shall lie against an order granting or refusing injunction or against an order passed in appeal, reversing or affirming the injunction order. So clearly we are giving the citation and injunction. No revision petition under section 7 shall lie again if granted or if rejected. Now they have the remedy in the main case. Because my lord, suppose my lord, what is my prayer? My house is there. How I will go? Whether in a house injunction can be granted? Answer is simply no. Only the person can be evicted from the house, but cannot be restrained that you cannot enter in your house because I am there since the 50 to 60 years. And I have my dwelling houses also. So in the IA, we have mentioned this. Then what you would see, home care retail marks here, the Honorable Supreme Court of India reversed the order passed by the Honorable Bombay High Court, wherein the Honorable High Court, while
Mr. Mahmood, you see, this observation was made by this court while dealing with a revision petition under section 115 of the CPC.
yes,
But present petition is filed under Article 227 also.
that is also there.
Then
That is also there. Kindly say,
now can you argue that this petition is not maintainable?
yes, no, that is kindly say to number 2.
So how this decision number 1 will help you?
Two kindly 2 and 4. Here, Honorable Supreme Court reversed the order passing by the Honorable Bombay High Court, wherein the Honorable High Court, while exercising its power under Article 2 to 7, had reversed the concurrent findings of courts below, where the injunction order was granted in favor of the applicant. The apex court observed that order may be right or wrong, but as long as the court set a jurisdiction to pass the order, such orders cannot be interfered with. Hereby it is 227.
So where it is observed that the concurrent finding is binding upon the High Court?
It is there.
Where it is there?
Para 1, 2, and 8. Para 1, 2, and 8. Concurrent finding is there. I am only minimizing the time.
Not minimizing the time. You are picking some of the lines from the judgment. That is not the procedure of referring the decisions. You produce the complete decision. We'll see.
No, then let me read then. This was home care. So kindly say the home care. That is the second case. Leave granted. The appeal is directed against judgment and order.
No, that decision is not before this court.
Hello?
Where is the copy of the court?
let's say, Bombay High Court in writ petition number so, by which the High Court in the exercise of its power under Article 227 of the Constitution of India has set aside the concurrent finding of the fact arrived by the courts below, by which an application for injunction filed by the preferent in a pending suit was allowed in the manner indicated in the said order. So exactly like the present case, madam. The title suit is pending and there is concurrent finding. Even the High Court interfered, Honorable Supreme Court interfered in the order of the High Court. Similarly, my lord, another judgment is there regarding.
No, you so this court where such observation is made by the Supreme Court. In which paragraph?
Number 3, last 3 lines may be seen. Para 3. In our view, the finding arrived at by the courts below cannot be said to be perverse or arbitrary, for which the High Court could set aside the said orders in the exercise of its power under Article 227 of the
No, Mr. Mahmood, you have submitted that the concurrent finding is binding upon the court, this court, where such observation is made by the Supreme Court in this decision.
Division of power, madam, division of power or Article 227, it is restrained by the Honorable Supreme Court. Because, my lord,
Is it your submission that this court, in spite of having found the case to be perverse, should not interfere with the same?
Perverse, my lord, that the court said perverse. Here the possession is the main thing. We are, whether I am entitled or not, but possession is 50, 60 years. If injunction is granted, how I will enter my house? So how it is perverse? In my opinion, well, it is not perverse. Because in house, no injunction can be granted. That is the injunction has been granted in our favor, but that cannot be interfered. Because if injunction.
Even if you do not have any right title and interest over the same.
Yes, but that is my main case. That is the main case. Here you get injunction. What is our submission is this: if your lordship interferes in the finding of the landed courts below, then what will be the consequence? We cannot enter the house. And if we enter the house, then 39(2) will come.
Already one school is there.
School is available, school has sufficient land. Now it is only because the headmaster has.
No, it does not mean that the remaining part of the land will be allowed to you to construct your house and to cultivate there.
In the main case, actually, if I am correct, what your lordship's query, these are the queries to be put in the main case, not in the injunction case, because I have the house, I have the possession. Even they have also admitted the permissive possession. Suppose, lordship, permissive possession, I have given someone permission, but he is not vacating. Admittedly, if I admit their person, he has allowed me to stay at some place. Now he has asked me to vacate my land, but I am not vacating. Then law does not allow him that by gunpoint or by using force he can evict me. He must take the shelter of law. So whether we are legally or illegally occupying the land since the 50, 60 years, so let us be practical, madam. Let us be more practical. Because since the 50, 60 years I am in possession, if I am, and they said that permissive possession, the permissive possession even cannot be ousted by gunpoint. So we have filed a title suit along with major case for injunction. So I think injunction has been rightly granted by courts below, because otherwise multiplicity of cases will arise. I will enter house, they will file a petition under section 39(2) of CBC that you have violated a contempt of court's order. So there will be multiplicity of cases. So long, but lordship may direct them that title should be disposed of as early as possible. But so far
No,
this-
there, you have not filed what
Doc-
they have not filed?
Documents not yet filed before the court
Documents.
for framing issues, Lordship.
Okay.
So your lordship may direct 1 or 2 months, 3 months, the main case may be decided. But injunction, if interfered by law, then it will be
No,
extremely.
no, even if it is perverse, we will not interfere it. Is it your submission?
Perhaps that I said that even no, they have said that permissive procedure, they have admitted.
No,
But
Mr. Mahmood, we have to examine whether there is prima facie case, that is balance of convenience and irreparable loss.
Court has ample power. Even court may send a commissioner to see whether our house is there and how many years we are occupying. So not a matter of 2 days or 2 weeks. 50, 60 years persons. Now my learned friend said that some new persons have come. No, they are not new persons. They are the son of the original person, but they have died. Some of them died. That's why their sons have come.
No, that should be mentioned, my lord. Why they have suppressed in the, my lord, plaint? There is no mention about the writ petition
If I have
before the High Court, my lord.
If I have suppressed, you raise this issue. You have every right to raise all these issues that you have suppressed.
And my lord, overall, this from this case is reflected there to land grabber. For land grabber, law how they how law will, my lord, help them. The land grabber, yes, my lord.
Whether he has filed any land grabbing case. There are 9 of these.
Bona fidely, they were, my lord, engaged for cultivating that land. And now they are preparing to, my lord, grab the land, my lord, permanently. Why they are not a land grabber, lordship?
Land grabbing case that we have no.
And Honorable Supreme Court, well, just I like to produce the judgment. You know. Law is very much clear here. Paragraph 6, 1, 5, and 6, my lord. Paragraph 1, I'd like to read out now. Fraud averts all judicial acts.
Okay, that's all
Excel-
right now. Not necessary.
My lord.
So if my lord is on that point, as commissioner may be sent on how many years we are living there with our family members.
No, no, in this petition, there is no question of directing
No, High
to
Court is
appoint
the
a
case of
commission.
Appointment. High Court can
No,
pass
no.
any order in the interest of justice.
We are only testing the order, impugn order.
Now, if your
We'll
lordship
see.
interfere, how will you enter the house?
You avail the remedy?
Hello?
You avail the remedy, whatever is available under the law.
My lord, lordship,
That is the main case.
would you respect,
What
my
you
lord?
have said,
Would you respect
lordship,
that house also part of agriculture, my lord? Whatever they are, my learned friend is submitting, the dwelling house, my lord, they have requested that where we will live. Accordingly, they were, my lord, they were, my lord, allowed to stay there. And now they are preparing to grab the land permanently, my lord.
Okay. Heard, Mr.
K. Roman.
Learned counsel for the petitioner, Mr. Mahmood, learned counsel for the respondent. Argument concluded, order reserved. We'll resume
Okay.
after 5 minutes.
Your Lordship, can we look to the last for the matter? Last for the like this.
Yes.
But they inform the court that the file has been taken from there. And they pray before the court, they will find application appropriate application before discussion. And today is fixed for that purpose, not for hearing.
Okay,
My lord, since the party came to me, earlier the party did not come to me, and that was the reason we submitted so. Now the party came to me, and they continue to engage me in this particular case, and accordingly file is with me. And today the matter is fixed for hearing, so the matter may kindly be heard and disposed of.
Today is not fixed for hearing, or that's it also.
okay, you are not ready, it means.
I am ready. He is not ready.
5th March. 14 pieces, 12, 12. 17, 17, I got vote for this. 19. 17 or 19? 19.
19. Okay.
Let it be.
As agreed by learned advocates of both the parties, recusal lays the matter on 19th of March for hearing.
Much obliged.
I mean 30. May I please, I think absorb it today. I have oversight the list of causes. Today I am not prepared. Any day your lordship may kindly give it. 19th.
19th. 19th.
19th.
Heard Mr. A.C. Sharma, learned senior counsel assisted by Mr. Vardas, learned counsel for the appellant, petitioner, and Mr. Your name, please?
M. Doctor.
M. Talukdar, learned counsel for the respondent. Mr. Talukdar submits that he is not prepared to argue the matter today and prays for listening the matter on some other date. They are allowed recusal lays the matter on 19th of March.
As part of madam.
As parted.
As
Okay.
part of. It was hard, madam.
Parted.
First.
All right. Okay.